some of them, people took to heart what I said about putting things in writing. Let's see, trying to think.
Want me to do mine?
Yeah, why don't you go?
So this one says, our property managers and site manager seem reluctant to take actions as follow-up on issues. How best to get them to perform? Site manager rarely works around property. Board minutes are not posted unless requested. What to do? I'm an owner, not a board member. That is tough because as a board member, you can hold employees' feet to the fire. As an owner, you have to express that to the board, and it's the board's duty to follow up on. But again, if you're not happy with the way your board is working, then you should run for the board. It's the best way to affect change, right? For board minutes, in John's handout, he talked about how unapproved final drafts of minutes of board meetings must be made available within 30 days after the board meeting. But made available doesn't mean that they have to be mailed to you or posted online or any such thing. It means that you might be able to go review them at the property management office. And honestly, I don't like distributing unapproved board minutes. I don't want to distribute them until my board has approved them. I don't mind making them available with the draft notation, but I don't want them out there because what if we do change something materially between the draft and approval? So that is something that as an owner, you do have the right to view. It does say board minutes not posted unless requested, so they are following the law there. You know, keep that in mind that as a board member, you'll have more rights to look at the minutes than you do as an owner. But you can still put your concern in writing to the property manager, and the board will have to respond whether or not you can get a copy of the minutes. That's mine.
This is a fairly fundamental, apparently at this project, the board went into executive session to discuss the budget. Generally, I would not have said that was an appropriate use of an executive session, again, if there might have been something about employees. If it was related to the cost of litigation involving the association, individual items on the budget might have been possibly subject to executive session, but generally, discussing the budget would not be an executive session topic. The law does actually have 4 topics. So unless anything on the budget were to fit into one of those 4 topics, it would be a question to me whether that, again, I think Rachel pointed out, it's not just to keep things, allow the board to talk about things in secret. That's not the purpose. There are 4 stated purposes. Your budget should be fitting within those purposes.
Should we torch recording?
Yeah, go ahead. I don't see too many for you.
Maybe that one, DCCA website?
You're not going to talk a little bit about the guy came up earlier.
Yeah, Gordon's going to give a little bit about...
Just before today's session started, a gentleman came up and asked me about Senate Bill 551, now that it's become law, and the applicability to everyone in the state now. So the short answer is that it's become law under Act 282, and it applies retroactively to everybody, so it applies to existing cases. So basically, it fixed the Intermediate Court of Appeals mistake, and it will have an impact on existing cases in that there will not be an ability for any court to dismiss a case simply because you didn't have explicit language in your bylaws authorizing the non-judicial foreclosure process. That's something that you're allowed to do by law. The one caveat to that is that the Supreme Court heard the appeal in a related case to Sakal, and I think this was just last month, John? In any case, the court might rule that the law would apply only prospectively, and in that case, it wouldn't have an impact on existing cases. But as it stands right now, with Act 282, The Sakal case has been corrected, and you do not need to have the explicit language regarding the authority to use the non-judicial foreclosure process in your documents.
Okay. This is a long question about fines and whether they're reasonable and appropriate, and I guess the basic answer to this question, if you've been fined and you disagree, there is actually a process now. You can ask for mediation of your fines. The law was changed to say that they are not something you necessarily have to pay the fines and then dispute about it. You can ask for mediation concerning your fines, and that would probably be your best bet. You can go to court and you can argue that they're unreasonable, that they're outside the bounds of due process, and that sort of thing. And I think this question basically points out to boards that it's always good to try to be good and reasonable in the beginning and not just slap people with fines. My personal philosophy is I try to be very fair to people in the beginning of enforcement, because then if they blow me off, I say, hey, my conscience is clear. I gave you every opportunity to resolve this in a reasonable way, and you blew me off, so I don't mind being mean to you now. It's your fault. And that actually works pretty well, because if people feel they deserve things, they're more likely to accept it. If they feel that you've been unreasonable with them, then I think you're more likely to have problems in getting them to feel that they've been treated fairly. Thank you.
If email meetings are procedurally wrong and used to omit owner participation and dissident board members, should those motions be ratified? R1R, Robert's Rules of Orderly Revised, said that motions and actions that are procedurally in violation of state laws cannot be ratified. So it's not in violation of a state law. So you can ratify it. Roberts does allow you to ratify actions taken outside of a meeting, or for example, at meetings without a quorum, so you can ratify it. It's just, I personally don't recommend the boards do this, because it does lead you down a dangerous path. However, regardless of what I say, there will still be the boards that do this. So again, what do? Try to get on the board. If you're one of those dissident board members that's being left out, make sure that you make that clear at board meetings. Vote against any sort of ratification of those motions. So you speak against the ratification of the motion, of the action taken by email, and then vote against it. Because then at least you went on record as stating why you were against it and you voted against it.
We have a question.
I don't know what to do with this one.
We have a question regarding the DCCA website listing the condominium reserves reference guide dated 1992 as a resource of information. So the question is whether it's still valid from 1992, and is there a more current such guide of reserves, guide for reserves? I don't know that there is for the Real Estate Commission, but regarding the law regarding budgets and reserves, when we adopted Chapter 514B, section on budgets and reserves, we basically imported in the language just a few small changes from 514A. So I don't imagine that a more current version of the budgets and reserves guide will add too much to what's in this 1992 condominium reserves reference guide.
You want?
Yeah.
Okay, so the to-do list idea. This question is, should the to-do list get published or just maintained by the president? I feel it should be maintained by the president and secretary and the property manager, because usually those are the people that are kind of running everything between meetings. This person goes on to say, I was always under the impression that the minutes should reflect what occurred at the meeting, so that if I was absent, by reading the minutes, I would understand what happened. No, it is not a recording or a videotape. If you wanted to be at the meeting, be at the meeting. If you can't make the meeting, the minutes are supposed to tell you what actions were taken. Not who said what, not everything that happened, is what actions were taken. They go on to say, our minutes are just the agenda with in progress or completed next to it, in addition to motions and votes. Honestly, to me, that sounds relatively proper. I would actually take out the in-progress items that I'm trying to do from my own minutes from my condo board and separate that out to-do list, so that way my minutes are indeed just actions. I might say, so-and-so gave a report, but that's it. If we didn't adopt any motions out of the report, I just end the sentence right there.
This could be Rachel and I. The question came to me, this is about the board putting the topics on the agenda for their meeting in a way that lets owners know what is going to go on. And the question is, basically, what level of detail should the board put? And I think you would come back to the basic principle. What was the legislature hoping to achieve? They were hoping to achieve that you would let owners know in appropriate detail what you are planning to discuss at your board meeting, so they have an idea of whether they should attend. And so, I don't know, do you have any?
I think that's pretty good. I don't like seeing just the item new business on a posted board agenda, because that encompasses absolutely everything. Everything could be new business. As long as I'm with John, you know, you can be a little broad. You don't have to specify the exact motion that may or may not be made at the meeting. And honestly, if my board meeting agenda said special assessment for owners, I imagine a lot of owners would indeed show up. So I think that's specific enough to tell the owners what's going to happen.
That's fine. Question, when the board doesn't follow the condo law, what recourse does the homeowner have? Capital punishment. Sorry, no, I don't think that's an option. But I've actually had situations where boards or certain members of a board believe that self-governance by the condo community meant that they didn't have to follow any law. They didn't have to follow the building code, they didn't have to follow the condo law, and that board eventually released me. But in any case, it's going to involve either getting that board out and getting elected to the board, or if you wanted to take some kind of a legal action. I've actually had boards where minority members of the board had to take a derivative action against the board members who didn't want to follow the law, and basically stand in the shoes of what that board should be doing, representing the association as a whole. But again, that takes time and money.
Okay. This is about the board spending maintenance fees, and are there any limits on them spending? And the basic answer would be that they should be spending them for the intended purpose. When you have reserves, the board cannot just take reserves for a non-reserved purpose except in an emergency. In this case, I guess the board had a full-time attorney. I don't know if they came to the meeting every time. What I used to tell boards years ago when I was a condo specialist was, once you elect the board, they have 90 and 95% of the control of your association. So that's why you have to do a good job in the beginning, because once you turn them loose, it's pretty hard to rein them in. And unfortunately, that's probably the answer to this question on limits on board spending is they have a lot of discretion, as long as they're not treating themselves to expensive meals at a steakhouse for no reason. That's the sort of stuff you can hang them by their thumbs. But if they're spending it, for example, I used to go to one board's meeting, and after a while I just told them, I think you're wasting your money. I just sit here and listen to things for 2 hours. You may as well ask me not to bother coming. And they agreed with me, and so I didn't go anymore. But that is something that you have to keep in mind. The board has a lot of discretion over spending your money, and it's hard to rein them in as long as they are spending for what's arguably a legitimate purpose. Legal advice, expert advice, anything like that, that would be a difficult thing to rein them in. Yes, Rachel had pointed out, there is something in the condominium law that you're not supposed to exceed your budget as a board by more than 20% in any given year. And I always refer to that as the no surprises for a year law, because if you read it carefully, the next year you can exceed your budget by 300% Nothing prevents you from doing that. The theory is when you adopt a budget on January 1, you follow that within 20% for that next year. Thereafter, you're free to do what you want, but that is a limit, so that's true.
This is a fun question. Can you suggest innovative ways to recruit effective board of directors members? So if you want people to show up at your board meeting, my dad said, institute a special assessment. You will have many people that show up at your board meeting who are not happy. Whether or not they're going to be effective is a whole nother issue. That's tough. Getting people to volunteer is very difficult. For a while, my 5-member board operated with 2 vacancies, which meant that as soon as one person couldn't make it to the meeting, we couldn't hold a meeting. And that was extremely frustrating. So it is a problem. Sometimes it means that your board may be doing a good job. It also might mean that ownership doesn't care. But usually, at least it doesn't mean that you're doing such a horrible job that people are beating down the doors trying to get on the board. Something. The follow-up one on this is, what are the pitfalls of I'm assuming a property manager running the board of directors meetings and controlling the budget? I'm not a big fan of a property manager running the board meeting, and that's not just because it might interfere with my own business as a parliamentarian running the board meeting. It's also because they are talking about items and maybe even putting things to a vote that directly affect them. For example, if it has to do with the budget, adopting the budget, that budget may include a raise for that property manager. If it's an annual meeting and the owners approve the property management contract, then that could be perceived as a potential conflict of interest for the property manager to be running the meeting, especially to be chairing that motion. So as much as I like to have the paid personnel do things, I don't recommend that property managers run the meetings. I think it should either be a professional presiding officer or the president.
These are 2 accounting questions which are sort of related, which is we're having a hard time getting an audit done as required by law. CPAs are refusing to do it. I think there were some problems. I'm not sure if they're resolved yet. There were these peer reviews for CPAs, and some of them didn't get their peer reviews done, so they were not supposed to do audits, but I didn't really spend a lot of time on deciding why. But the second question is, are there any penalties for not auditing your financial statement for 3 years? The board's excuse was they couldn't find an accountant. That probably would be a valid excuse if it's true, but it's probably good even for a board to try and have the audit done because it's protection for the board. If the auditor says everything's been done right, your money's been spent properly, there's been a careful financial policies followed, that helps the board because again, when you serve on a board, 2 rules: do a good job, and number 2, protect yourselves from unnecessary liability. And having things like audits, hiring a engineer when you need engineering advice or something like that, those are all ways of protecting yourself. But I'm sorry, I don't have enough information why there was supposedly a shortage of auditors, but I was told it was to do with peer review and the fact that some of them had not got their peer review and weren't supposed to be, but again, I'm not sure. So there is liability because the law says if you're above a certain size, you do have to have an audit. If you don't, you're going to have some good excuses if you get called on that. And I'm not sure whether the state would look into that. They do look into some financial issues. I can't remember whether the audit fits in there.
You know, John, real quick related to that, when you talk about doing a good job and part of that being going to your accountant or some expert when you need to have particular advice, part of the importance of that is that courts generally give deference to association board decisions based on the business judgment rule, but you lose the benefit of that if you don't, right?
Yeah. So that's a very good point. I always say it's like mathematics. I was terrible at mathematics, and you notice I didn't do a PowerPoint today. I don't know. But you get more credit for getting the right working, even if you got the wrong answer. I could often in mathematics get the right answer, but I didn't have a clue how I'd done it. And the math teacher told me that's not the way to do it. You want to show the 1 and 1 equals 2 analysis, which is what Gordon is saying. You want to show that you have done the appropriate analysis, you've done your due diligence, you've behaved reasonably, and that is something that as a board member you should keep in mind, that you want to show that you have followed the right process, even if you got the wrong answer. There's a lot of benefit to following the right process, even if you get the wrong answer. Just a couple of, this is to do with executive sessions Rachel may have. Can the resident manager, site manager be present in the executive session? Generally, they can if they will be helping the board make an informed and reasonable decision. Otherwise, maybe not, but they should be subject to the same confidentiality requirements for anyone else, for board members or anyone else. So it depends on what they're providing. If the board needs that information from the resident manager or site manager, it would be appropriate to have them in executive session, but they should be subject to the same thing. And then this is a question about, should manager reports be given out to the owners? And it's a similar thing. If the resident manager report says that Mr. So-and-so was seen flashing people out of the window of his, that might be something the board would want to know, but I would not recommend distributing that to the owners. So that's when we come back to executive session, potential legal issues, qualified privilege to say things in executive session that you couldn't say outside. So again, when you're talking about managing agent and site manager reports, it depends what's in them.
That's pretty good. I agree with him completely.
He's right.
Because he's right. This one is, one of our board members lives on a neighbor island. Is it okay for him to attend via phone or video conference? So John and I were discussing this. The law says that the board may conduct their meetings by video or teleconference. So as long as the board is okay with that, then yes. And some groups function just fine that way. Especially when I first started doing this line of work in 2004, I had this idea that all board members should be resident owners, they should all be on the property, but my position on that has definitely evolved over time. Now I like a mix. I like a mix of resident board members and also board members who aren't there, either they rent it out, let their family live there, etc., because you want to have a bunch of different viewpoints represented. You don't want it to be only one. So in this case, as long as the board allows that teleconferencing or video conference in some situations, then it's fine. The law does allow for it.
So related to that, we had a question about whether or not a board member needed to live on the property. And so as Rachel answered, you don't, you just have to be an owner.
Yeah. There is one group that I serve where there's a requirement that one board member be a resident of the state of Hawaii. But they don't have to live on site, they don't have to live on that particular island, but they have to be a resident of Hawaii.
Okay, I think we're actually coming towards the end. If you didn't get your question answered, you can ask, but are financials accessible to owners if owners ask for them? Yes, they should be. Now again, subject to possible confidentiality if it involves certain things that legal issues or that, but that's part of the owner's right. As part of their self-governance supervision of the board, they have to be able to know that the board is not wasting their money, misappropriating their money. And I believe maybe the condo specialist, I think that would be something that the commission would look into as far as documents and that kind of thing. You may want to ask them. If they refuse to answer questions about the financials, that's a little harder to say because they could turn around and say, read them yourself. So I don't know that you would think they would want to. And then if they're not maintaining the building, I can't work out whether this is the manager or the board. Ultimately, the board is responsible for maintaining the building. And if they aren't, as Rachel had pointed out earlier, they have some potential liability, because if something goes wrong, it's just not worth it. If you cheap it out and don't maintain things and somebody trips and falls or some other thing happens, you as a board member can have increased liability. Can a new board member be voted on after the yearly voting? They can be voted on by the board. I don't know if they would say voting, but they can be appointed by the board, but they are only supposed to serve until the next association meeting, whether it's annual or special. And then we come back to board members are spending money unnecessarily to the, and I'm sorry to tell you that they do have a lot of control unless you can show that they're actually wasting your money on things that aren't related to the building. And owners have to pay more money due to the neglect of the building. Unfortunately, you probably have to run for the board with a lot of like-minded people who want to turn things around, because the board is only there because the owners let them be there. Of course, if you have owners who just don't care, you could be stuck, but that's the bottom line, yeah.
John, on that question, there was one that it wasn't clear whether or not it was the managing agent, property manager, or the board that was being referred to. And just to be clear, the managing agent serves at the direction of the board. And so if certain things aren't getting done, it could be that they didn't get the approval of the board to do it. But the managing agent can't act independently and just do things that haven't been approved by the board.
Yes, and that's the famous memo to file. Many managing agents make recommendations to the board and the board blows them off. So then they put a memo to file, because the number one rule of condo land is it's always the managing agent's fault. And they want to have a record that it isn't their fault, that they advised the board to maintain the building and the board did not follow through, because that brings everybody down. And then I would like to just give a quick thing on, what if the resident manager is acting as conflict of interest, the manager is racist, unfair, a bully? I would say the board has got some problems there, because that person is acting for the association, and if things go sideways and the owner brings a discrimination complaint or anything like that, and the board is aware of this and they have not done anything, then I don't think it's going to look too good for them. And certainly the association could end up forking out a lot of money if that's true, if the manager is behaving in a racist and discriminatory manner. And then if the resident manager threatens to slap a legal fee for bringing up an issue, again, I don't think the resident manager would be in control of that. That should be the board's decision, if anything, possibly the property manager. So whoever is in this association, you may want to call the condo specialist for a little more detailed advice. You may even have to call the Hawaii Civil Rights Commission if you feel that it's discrimination based on race, color, creed, anything else like that. But the incredible thing is, notwithstanding all if everybody does what they're supposed to, the manager, the board, the resident site manager, things actually work pretty well. But if somebody gets out of line and starts doing more than they're supposed to, or doesn't observe the limits on their authority, that's when it all goes bad.
Just to put John a little bit here and put things in perspective, there are over 1,700 associations in the state. And when the legislature gets to listen to some of the complaints that I brought up, they have a pretty skewed perspective. Because again, it only comes up here because there's a problem. But it may not be representative of very many associations at all. Most are well run.
There's trouble at around 10% or less. So out of 1,700, maybe we see 170. So most of them work fine. It's just the really loud people that go to the legislature.
And I would like to emphasize that exactly what Gordon says is part of the problem. The law gets changed because one side of an issue is presented, or one or two condominiums have a problem, and suddenly you're all subject to a new law that's supposed to deal with a problem you didn't even have. And that is the importance of what Gordon was trying to tell you, is make sure your opinions and your actions are known when these things are brought up, because otherwise they do go through.
Can I get this last one?
Yeah.
I just wanted to take this last one. I'm a board member, and I would like information on how to effectively confront existing property management company with their deficiencies, and request information on the process to change property management company and to hire a new one. So first, you need to look at the contract and see what's required to end it. Is it one of those you give notice 30 days, or is it one where you have to give a lot more notice? I think we were surprised, not with our property management contract, but I think think one of our other contracts, we found out that we actually have to give them a year's notice if we miss this little window that they gave us. So review the contract carefully. Once you have reviewed it, then you can always make a motion at a board meeting. If you are indeed a board member, then you make a motion to give notice or to request bids from other property management companies. And you can request them to come and present to your board. Because most often the board has, as you heard, about 95% control of the association. Usually they choose the property management company. Occasionally owners approve the contract, but owners don't choose who to put forward. So the board chooses the manager and sometimes owners approve the contract. So you got to take it up with the board.
Okay, and I think we're pretty much, in fact, we're way out of time, so we really appreciate it. It's always nice to see people show up. That's a good thing, and we appreciate you taking the time. You can come and talk to us after, but I think we have to start leaving the room soon, so that would be in. You can always contact the condo specialists. They have a lot of background on a lot of these issues too, and I think if you go out there, they have pamphlets on a lot of these issues about dispute resolution and that kind of thing, so it would be worth doing. But thank you all for coming. It was appreciated.